May it please the court, my name is Glenda Grosjean. I represent the petitioners, the Sedlocks. The Encinitas United School District, the EUSD, violated the Establishment Clause of the U.S. Constitution when it contracted with the Joas Foundation to bring Ashtanga yoga, which is a religious form of yoga, into elementary schools in their district. The trier of fact in the trial court, Judge John Myers, found Ashtanga yoga to be religious, yet surprisingly found that the teaching of this religious yoga was not violative of the Establishment Clause. The Establishment Clause says that Congress shall make no law respecting an establishment of religion. There are two tests that the court uses to determine if there is a violation of the Establishment Clause. The first case is the 1982 case of Larson v. Valente. And the second test is the Lemon v. Kurtzman test. Now, almost all trial courts use Lemon v. Kurtzman to see if there's an establishment of religion. There's the three-pronged test. But I want to talk a little bit first about Larson v. Valente, because I do believe that that should be the predominant test in this case that the court uses. Now, the standard of review for this case would be heard de novo. Whenever there is a historical, a mix of facts in dispute as well as law that's in dispute, the standard that should be used is de novo. Now, the Larson v. Valente case, in that case, the plaintiffs argued, and the Supreme Court agreed, that the law that was in question there violated the separation of church and state by giving preference and benefit to one set of religious organizations over another. Further, the court found that the Lemon test did not apply to this dispute because it was intended to apply to laws affording a uniform benefit to all religions and not to provisions that discriminate among religions. The case in Valente discriminated between religions because religions that had more than 50%, the statute said that provisions that had more than 50% of its donations that came from members of that religious organization were exempt from taxes, whereas the rest of the organizations were subject to taxes. So they were showing preference for one religion or certain religions over another, and that was found to be in violation of the Establishment Clause. Now, Congress shall make no law respecting an establishment of religion. It doesn't just say Congress shall make no law establishing a religion, but it says not even respecting an establishment of religion. EUSD is bound to obey congressional laws as they fall under, as the EUSD themselves fall under the executive branch of the government. The legislative branch, as you know, makes the laws, and the executive branch carries out or enforces the laws. As a school district is charged with the responsibility of enforcing the laws that apply to education. They were supposed to comply with all of the components of education, including physical fitness. Now, they decided to add a religious program to their physical fitness program, which was the Ashtanga yoga program. We concur with Judge Myers' opinion that he cited, stating that Ashtanga yoga is in fact religious. Now, he went on to say that the reason why there was not a violation of the Establishment Clause in this particular case was because they changed the names of the poses to child-friendly names. There's an old adage that says a rose by any other name would still smell as sweet. Ashtanga yoga, no matter what you call it, is a religious yoga. He found, as the trier of fact, that it was religious, but said because the names of the poses were changed that it was no longer religious, and we disagree with that portion of his decision. Now, the EUSD went beyond their scope of authority. They were supposed to enforce the laws as their authority came from the executive branch. If they wanted to incorporate a particular kind of physical activity, they could have, instead of taking it, Timothy Baird, the superintendent, could have taken his case to the legislature and said, California legislature, I want Ashtanga yoga considered, and had one of the legislators write up a bill and see if it would be passed. That is the way laws are supposed to be formed. But instead, he took this petition to the Joas Foundation. He took his proposal to the Joas Foundation, and then upon receiving over $500,000 grant, he took this proposal to the trustees of the district and said, we think that we should, they voted that we think that we should incorporate yoga as part of our physical education program. They voted and agreed. Now, that was not within their realm of jurisdiction. They were supposed to enforce the laws, not make up new laws. So instead, they incorporated this new form of physical exercise, and when the parents complained, the school district just changed the names. They didn't change the practices. Now, there was a religious teacher that they hired from the Joas Foundation, Jen Brown. Jen Brown worked and was trained by this religious Joas Foundation to teach Ashtanga yoga, and then she was subsequently hired by the school district to teach it at Capri Elementary. Now, before I get into those details, I just want to finish up with my Larson v. Valente. So the reason why I believe that Larson v. Valente is the proper standard in this case is because the conclusion in Larson was that no state shall aid or prefer one religion over another. Enforcement of such a statute would require excessive government entanglement with religion. But this wasn't even a statute. This was a board of trustees voting to do something that the legislators should have done. The legislators should have done. They were beyond their scope of authority. Both Lemon and Larson, both tests, were dealing with statutes that were already in place. This wasn't even a statute. This went way beyond their authority, and it did aid or prefer the Hindu or Buddhist religions over the other religions of the kids that were taught in that school. My friends, my friends, stated that they don't believe that there was a violation of religion, and they based their conclusion on the Lemon test. So I'm going to move to the Lemon test. One last quote from the court. They said that the Lemon test did not apply in Larson v. Valente because Lemon dealt with one religion, whereas Larson dealt with preferring one religion over another. So on to the Lemon test, which is the second test that will prove that the Encinitas School District violated the Establishment Clause. Under the Lemon test, there's a three-pronged test. There's a secular purpose. There must be a secular purpose. There reasonable child standard, the reasonable child must believe that the thing being taught, the government, they, in this case, they would have to prove that the government did not promote or inhibit religion. And then the third test is whether there was an excessive government entanglement with religion. So under the first test, there is not a secular purpose for the EUSD program. The Nancy Joas is the daughter-in-law of Patavi Joas. Patavi started the Ashtanga Yoga program and made it famous in Encinitas. Nancy also taught at Capri Elementary. She taught kindergarten at the same time that she taught Ashtanga Yoga at the Joas studio. Now, Encinitas has so many yoga studios on every corner, basically. They're everywhere in Encinitas. And Ashtanga Yoga became very popular from the 1960s through current day in Encinitas and the surrounding communities. Jen Brown also worked for the Joas Foundation, was trained through the Joas Foundation, and she was hired at the same school that Nancy Joas taught at to teach this religious program. In addition, the school took over $533,000 bribe from the Joas Foundation to introduce this form of yoga to the schools, to elementary schools. Now, my opponents say that there was a secular teacher brought in to write the curriculum as instructed by the Joas teachers. However, that secular teacher did not know about religion. She did not know about yoga at all. And so the Joas instructors actually came in and told her what to write down, how to do the moves, what to include in the curriculum and what not to include. So she wrote the curriculum, but she didn't write the curriculum. The Joas instructors told her what to write down. So I think that those factors prove that there is not a secular purpose, but I believe that it shows that there is enough circumstantial evidence that there was an ulterior motive to Timothy Baird in allowing the EUSD program, the yoga program, to be taught at Capri Elementary School and then expanded to the other districts after receiving over $500,000 from the Joas Foundation. I'm going to move on to the second prong, the reasonable child standard. The reasonable child standard was used in Lemon and in other similarly situated cases. Would the reasonable child think that there was a promotion by the government, by the school district, of religion when they saw the yoga poses? I would contend, it's our position that they would. First of all, there are many Hindu deities all over the place in Encinitas. There is a big Buddhist and Hindu culture there, especially because of the yoga studios. You walk into any yoga studio in Encinitas or in the surrounding communities and you will see a Hindu or Buddhist deity in the lotus position. Now, my opponents say that the lotus position is acceptable, and Judge Myers found that the lotus position, there was nothing wrong with it because they changed it from the word lotus to crisscross applesauce to make it child friendly. But a religious position is still a religious position. So with the reasonable child standard that was used, I'm not sure that that's the appropriate standard. The appropriate standard is someone who is similarly situated to the plaintiffs in this case. In this case, the plaintiffs were children from Encinitas. So the reasonable child standard from Encinitas is the proper standard, not just a reasonable child standard. So the reasonable child from Encinitas, who the trier of fact in the trial court, Judge Myers, found that the students are regularly exposed to yoga outside of the class because they have yoga studios everywhere, and Judge Myers even said they go to these yoga studios with their parents. So with them seeing the Hindu deities in the poses that they're doing in class, there are the Buddhist and Hindu statues in the yoga studios. There was the Ashtanga Yoga 8-limb poster that was hung in the classroom along with the postcards, and Jen Brown read from The Myth of the Asanas, which talked about the yoga poses and how they related to worship of gods. Now, there are significant facts that tie this case to Lemon too. Both the nuns in Lemon and the Joas instructors in this Sedlock case, they both testified that they did not inject religion into their secular classes. Both the Lemon and the Sedlock case had schools that were close to these religious places. The schools were close to churches in Lemon, and the schools in Encinitas are close to the yoga studios in the case before you. Both the school buildings had religious forms. In Lemon, there were crucifixes. Sedlock has posters, has the children drawing mandalas, not even in phys ed class, but in regular class, and there were religious postcards. And then 2/3 of the Lemon teachers were religiously trained. 1/2 of the yoga teachers in the Sedlock case were Joas trained, including Jen Brown, who still teaches there. And both take place in primary schools, where Lemon said an extra weight had to be given because they were impressionable pupils. All of this goes to prove that the reasonable child from Encinitas would think that there was a promotion of religion by incorporating this religious. They would see religion when they did the worship poses that included praying hands and a bowing child called the child pose, and the lotus position that many Hindu deity are found in. The third prong of Lemon says that there's an excessive government entanglement with religion. Candy Brown was the expert witness used by the plaintiffs in the initial case, but she wasn't the only expert. The judge wrongly found that the case hinged on Candy Brown's testimony. Now, her testimony was without question professional. She's very well educated, and Judge Myers praised her for her education and saying that there was no one better qualified, and he based his decision that yoga and Ashtanga yoga in particular are religious because of her testimony. But there was also, the plaintiffs also quoted from John Campbell, who was a certified Ashtanga yoga instructor, who talked about the spirituality and how the spirituality cannot be removed from the physical movements of Ashtanga yoga. Sabine Henriksen Schrems and Peter Versteeg also said that there's a shift that seems to take place towards spirituality once people start doing yoga. The fact that the 8th limb of the Ashtanga yoga model is unity with a deity or with a divine goes to show that this is a religious form of yoga. And the EUSD program only changed the names from the original curriculum. They still do the same breathing, they still do the same movements, they still do the exact same program. They only change the names. And they are selling this as a new packaged item void of religion because they changed words like lotus to crisscross to make it child friendly. It doesn't take a genius to know that that program, which is inherently religious, by changing the names of it, would still be religious. So in conclusion, we believe that the Larson test is the appropriate test to apply because we believe that the EUSD did prefer Hindu and Buddhist religion by choosing the Joas Foundation to teach Ashtanga Yoga, to have their teachers come in and help write the curriculum. And by taking the $500,000, $500,000 bribe from the Joas Foundation. Additionally, if the court does decide to find find that lemon is the appropriate test, there is enough circumstantial evidence to prove that there was not a secular purpose for the EUSD yoga program. There was also the reasonable child standard from Encinitas would believe that there was a promotion of religion by the school district, and there is an excessive government entanglement with religion. To quote from Larson again, the Larson court concluded that no state shall aid or prefer one religion over another, and enforcement of such a statute, talking about the statute in Larson, would require excessive government entanglement with religion. But this wasn't even a statute. This was something that the trustees decided to do. They bypassed the right way to make a change to the law, and they they went beyond their realm of authority. So we would ask that this court affirm Judge Meyer's decision that Ashtanga Yoga is in fact religious, and reverse the part of the decision and remand it to the lower court to correct their decision, to show that that because it is religious, it is an excessive government entanglement with religion in both Larson and Lemon to allow it to be taught in the Encinitas United School District. Thank you.